23-105-879-CZ. This is the plaintiff's motion to amend complaint. Mr. Jahn is represented by attorney Adam Flory, who is in the courtroom. County of Huron is represented by attorney Matthew J. Zaleski, who appears via the Zoom application. Mr. Flory, you may proceed.
Thank you, Your Honor. Adam Flory on behalf of the plaintiff, Casey Jahn. Your Honor, this is a motion to amend the complaint. Your Honor, as the court is aware, we're very early in the going on this file. We've we've met a couple times briefly to discuss scheduling of the status conference, but given the filing of this motion, we've put that off appropriately, Your Honor. And so we've not even had the initial pretrial on this file. There's only been initial pleadings filed thus far, and I believe the defendants have filed their initial disclosures. And so at this time, Your Honor, the plaintiff is seeking to amend its complaint to add a claim under the Open Meetings Act, which would render this count to be a two-count complaint with the OMA claim and a claim under the Freedom of Information Act. Your Honor, the court, I know, is well aware on the law regarding amendments of pleadings. As the court's aware, leave to amend should be freely granted where justice so requires. And Your Honor, leave to amend should only be denied for particularized reasons, such as dilatory tactics, futility, or undue delay, or things of that nature. Your Honor, as we go through in our brief and establish, I don't believe that any particularized reason in this case exists. Specifically, certainly there can be no undue delay, as again, it's extremely early in the litigation. We've not even had a pretrial conference yet. Moreover, Your Honor, there's certainly no history of failure to cure defects through previous amendments or anything of that kind or nature. So that leaves the only other possible basis, Your Honor, which would be futility. And that appears to be the main ground on which the defendant opposes the motion, although there is some reference made to undue delay in their responsive pleadings. But again, Your Honor, in regard to futility, Your Honor, I would simply say the following. Number one, the Open Meetings Act claim is timely pursuant to MCR 2.118D of the Michigan Court Rules, which is the relation back provision of the court rules. Your Honor, the amendment of this complaint and the adding of this claim would relate back to the original filing of the complaint, which would render the claim timely. The reason it relates back is because it arises under the same course of conduct. Your Honor, this was part of a pattern of my client's interactions with the County of Huron and attempt to gain information and to participate in local government and its process. Both the Open Meetings Act and the Freedom of Information Act are governmental accountability statutes. There's so-called sunshine statutes where they regulate the actions and behavior of local government. As the court's aware, my firm represents upwards of 40 municipalities, and I interact with these statutes all the time. And again, they largely have the same goal. One regulates the processing of documents, another regulates the administration of meetings. But again, they're both government accountability statutes. And the course of conduct in this case was my client's interactions with the defendant and efforts to participate in local government and gain access to information, which efforts to go to and participate in a meeting, efforts to procure the provision of documents. So they do relate to the same course of conduct, Your Honor, and therefore it would be timely under 2.118 subpart D. Moreover, Your Honor, I would note that setting that issue aside, the futility has to be obvious from the face of the pleading. In other words, the court is not able to dive in, or the party's not able to dive in and look at it on more substantive grounds. So essentially, as long as the pleading states a claim upon which relief could be granted, then the amendment is proper. Largely, Your Honor, I would respectfully assert that so long as the pleading could survive a C8 motion under 2116, then the amendment is proper. And again, that's based upon dozens and dozens of well-established cases that are cited in our brief. So again, Your Honor, number one, the amendment is timely. Certainly the amendment is timely, and I'm not sure what the reference in defense counsel's brief to untimeliness is, unless it's a reference to the claim itself. But we're here in the very early going, not even been a pretrial conference. There's no history of not following orders or failure to cure problems through amendments in the past. So there's simply no reason, no particularized reason to deny the request to amend. As to the futility issue, Your Honor, again, the claim is timely because it relates back under the same course of conduct under MCR 2.118 subpart D. And lastly, Your Honor, again, from the face of the pleading, it states a claim upon which relief could be granted. Anything beyond that, Your Honor, has to be filed through a motion for summary disposition. If defense counsel wishes to test the veracity of the claim under C7 or C10, that's certainly within counsel's purview to do so, but that's beyond the face of the pleading. The face of the pleading is valid. It states a claim on which relief can be granted. And to go beyond that is beyond the scope that's appropriate for a circumstance where the complaint is trying to be amended. With that, Your Honor, we respectfully request that the court grant the motion to amend and allow 14 days for an amended complaint to be filed.
Very well.
Thank you, Your Honor.
Mr. Zalewski.
Thank you, Your Honor. Well, plaintiff's counsel is correct in that our argument, as the court is aware from our response brief, is that the proposed amended complaint is futile. And we would submit that it does not survive would not survive a C8 motion on its face. And the reasons for that are multifold. Number one, on the issue of the statute of limitations. Now, that is specifically with respect to the provision of the OMA regarding invalidation of any decisions at the July 11th meeting. Plaintiff has submitted that it's part of some sort of course of conduct and somehow should relate back this claim to the original FOIA claim. But we are not looking at an original complaint that's talking about a course of conduct or access to government. We are looking at the original complaint as a FOIA claim regarding one specific claimed FOIA request. It is an extraordinarily narrow complaint as it's originally pled. It is not this sprawling question of government accessibility, as brother counsel has suggested. So too is this proposed amended complaint. It is a very specific question as to one meeting. It simply is nothing more than that. There is no pled plausible claim of some broader Open Meetings Act violation occurring. So we would submit that this proposed amendment does not relate back to the original claim because it is not at all the same conduct, transaction, or occurrence as that one claimed FOIA request that is at issue in count one. So accordingly, the statute of limitations of 60 days would apply for bringing an invalidation claim under the OMA and should bar that portion of count two as proposed. Plaintiffs did not address any of the other issues. This is ultimately a question of whether any of the relief is available in the proposed amended complaint as pled. And as the county has argued, it is not. So, for example, beyond the invalidation request, there is the request for injunctive relief. It is a sweeping request that's being made in this proposed amended complaint for the court to order compliance with the OMA at all times, except that the count two is only relating to a single meeting. There's no pled plausible basis of finding that there is a sweeping OMA problem here. It's one meeting. So it is unclear what plaintiff is seeking to enjoin. That meeting is over, and there's no indication in the proposed amended complaint that there's any ongoing violation that would require an injunction. So on that basis, that request for relief is futile. There is a request for a fine, but the statute under which that is pled is related to criminal prosecution for a misdemeanor violation of the OMA, and clearly this is a civil case, so that relief is not available. There is a request for actual and exemplary damages. However, that is pled under, there is no clear statutory reference in the proposed amended complaint for that. The only provision of the OMA where that relief is available is a claim against a public official. Here we have a claim against a public body. And ultimately, the request for declaratory relief, again, not pled under a specific statute of provision of the OMA. So right there, that's concerning. But again, much like the injunctive relief, in order for plaintiff to have standing to bring this declaratory action, there has to be some live case or controversy requiring the party's future rights to be adjudicated. And again, we're dealing with a proposed count 2 that deals with a single meeting in the past. There's simply no need for the court to issue declaratory relief, even under the most generous reading of the face of the complaint. So we certainly believe on the face of the complaint or the proposed amended complaint that this amended complaint could not survive a motion for summary disposition under C8, C7 at a minimum. And that's exactly the standard for futility. If a complaint as proposed could not survive that motion for summary disposition, then it is futile and leave to amend should be denied. And so that is what we're asking the court to conclude today and to deny the motion for leave to amend.
Thank you. Mr. Floyd.
Thank you.
Thank you, Your Honor. Your Honor, again, the statements contained in the complaint are there that state my client desires to participate in local government. My client desires to attend public meetings. My client is making docket requests to obtain public records. So the statements referencing my client's efforts to participate in local government are in the complaint. Moreover, the statutes themselves speak for themselves in the fact that they are sunshine statutes that regulate the transparency and effects of local government. So that relates to the course of conduct, Your Honor, and under 2.118D, and would render the invalidation provision timely. Moreover, Your Honor, that's only, again, that's the 60 days is only in regard to the invalidation. Essentially, counsel's argument appears to be that the county can violate the Open Meetings Act, and that's just not a big deal because, and therefore no injunctive relief is needed. Your Honor, that's flat out wrong. I've seen complaints of this nature and of this kind get filed and obtain relief numerous times. Municipalities are not allowed and public bodies are not allowed to violate the Open Meetings Act and then somehow claim, well, this is just an isolated incident, we won't do it again. That's the point of the Open Meetings Act, Your Honor. It has a separate provision for injunctive relief to ensure that this does not happen again. We're not required to just take the public body's word for it that they are not going to violate the Open Meetings Act again. So I'm also somewhat stunned that counsel thinks that an injunction requiring compliance with the Open Meetings Act is quote unquote sweeping relief. I think compliance with the Open Meetings Act at all times is the absolute minimum that the county would do. Now, it's not considered sweeping relief to request basic compliance with the law. So again, Your Honor, at this point, the analysis is somewhat far afield. The sole question is, would this survive a C8 motion? The answer to that is yes, Your Honor, because number one, it relates back under 2118D. Number two, Your Honor, we have set forth a cognizable claim for injunctive relief. Now, counsel may disagree with that. That's what litigations are for. That's what discovery is for. That's what motions for summary disposition are for. But we've established a violation of the Open Meetings Act. Notably, counsel did not even take the time to deny that occurred. We've established that that occurred. The Open Meetings Act has a statute to provide for injunctions when that occurs. That's what we put in our complaint, Your Honor. That's a cognizable claim. And we request that the court grant the motion to amend and allow us to 14 days to provide the amended complaint. Thank you, Your Honor.
Very well. Thank you. What is in play, excuse me, is MCR 2.118 regarding amendment of pleadings. And obviously that has been cited and stated by counsel throughout. The issue before the court is whether or not the amended count 2, if it's allowed to proceed, that is to file the amended complaint, fails to state a claim or is legally insufficient on its face. Now, the argument against it is, hey, look, it's futile. It is absolutely futile. There's no reason for this. And as a result, it should not survive. The issue for the court is really whether or not it does indeed relate back. Now, there's an argument that says it should relate back, hence the complaint be allowed. There's an argument saying it should not relate back, hence statute of limitations. It would not survive under a C7 or potentially C8. As a result, the amended complaint should not be added. At this point, because the court does not completely have enough information as to whether or not it relates back or not on its face, I don't find it futile at this point. Now, that doesn't mean that it can't be, that it would survive subsequent C or 2.116 motions. But at this point, I don't have enough information to say, hey, look, it doesn't relate back. Hence, it's futile. We're done. So motion to amend the complaint is respectfully granted.
Thank you, Your Honor.
In order to that effect.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Have a good day.